Good morning, everybody. I don't know if anybody else is going to be joining, but it's almost 10 after, so I figure we can go ahead and get started. So about a month ago, we had an opportunity to come on and started to discuss the New Jersey real estate contract. Not sure how many of you had an opportunity to be on for that portion, but for those of you that weren't, my name is Greg Voorhees. I am a real estate attorney located in Medford, in Burlington County, South Jersey. I've been doing this for about 16 years now, and so I handle residential commercial real estate on a daily basis. And this contract that we're about to switch over to kind of forms the basis for 95% of the deals that I'm involved in with local agents, buyers and sellers. So on our last go around, we had kind of made it through the first half of the contract, concluding with the inspection portion of things. So we're going to pick up and address the second half of it. So I'm going to go ahead and share my screen to bring up the contract in just a moment. All right. And if somebody could just do me a favor and tell me if they're able to see the contract, starting with looks at the top of the screen, it'd be paragraph 17. Can anybody see that? Hello.
Yes, can see it.
All right, great. Thanks. Appreciate that. All right. So what we're going to do is pick up from here. A lot of this portion of the contract deals in essentially boilerplate disclosures, things of that nature, which don't frankly come up very often. There are items that are in the contract. I would say over the last 16 years, when a dispute involving anything having to do with this has been extremely few and far between, with the exception of conversation about bulk sales that we'll get to in a minute. But just in terms of briefly on this, because it's really not a hot button issue, the Megan Law items, there are Megan's Law registries that are available online. You'd probably be amazed at how many more people qualify under this. That you'll see dots if you look at it than you would probably think. But it's not something that most property owners really have any idea about. So I wouldn't expect any disclosures, and generally from your seller's perspective, there's really not much to disclose there. It's public information. Similarly, off-site conditions. These are things that most of the time in South Jersey you don't encounter. I've encountered this once before in a property that was down in Cumberland County that was near a salt mine. I had a client that asked about the mine and what would be, potential air quality impact from the mine. Again, this gives you an ability to reach out to municipalities, see if there's anything that qualifies, but not something that would be very common or major. Airport safety zones. This just gives you a list of all the airports that are in New Jersey. Doesn't give you any indication as to flight patterns or anything. Oh, I'm going to go ahead and mute whoever that is. In any event, this gives you just a list of where they are. Not going to tell you flight plans, things like that. So, typically what I recommend when I have buyers, if they're in and around one of these areas, visit the property a couple different times a day randomly, just to get an idea if there's any crazy noise. Sellers should disclose this to you, but there are other things that would exist in the world that cause noise, gun ranges, things like that. So it's always just a good idea to do a little investigation of the property. But this is just kind of a disclosure to let you know what may be in your area. All right, we're going to take a few minutes to talk about bulk sales, as this is something that can be a kind of a confusing item. So bulk sales is basically the way the state of New Jersey ensures that it gets paid taxes from those that are obligated to pay taxes on the sale of their properties. So when it comes to standard run-of-the-mill deals where you have a seller that lives in a property selling a property to a buyer, this provision is completely not applicable. You don't have to worry about it. It only comes up in the instance of commercial property or dwellings that are owned for the purpose of basically multi-unit dwellings that are rentals. So 1 and 2 unit dwellings are not applicable. So if you have a shore home that's a single or a duplex that's being rented by a New Jersey resident, it's not subject to bulk sales. Where it comes into play is if you have, 3 units or more, properties that are owned by LLCs, or out-of-state residents occasionally come up. So if in the event something like this is a possibility, I always recommend reaching out to an attorney, because what the impact is and what happens is you send out a form that is a New Jersey prescribed form. It gets filled out with seller information and the buyer information, attach a copy of the contract, and it gets sent to the state of New Jersey bulk sales department at least 10 business days before closing. What they then do is they evaluate to see if the seller has any back New Jersey taxes they're due and owing. If they do, they will actually then send out an escrow letter saying that the title company is required to hold funds in escrow, and then you're fine. You close, that money is held from the seller proceeds, and the seller basically has to sort it out with the state. Like I said, this generally comes up with properties that are multi-unit rentals or commercial properties. The big exception that exists with bulk sales is if you're buying a rehabilitated home. So let's say that the company an LLC buys a property, fixes it up, and resells it. If they're in the business of buying, rehabbing, and selling homes, bulk sales does not apply to them. So where it does apply is if a trust holds a home, keeps it for 20 years and eventually goes to sell it after renting it out, bulk sales could apply there. It always applies in commercial properties. So if you're involved in a commercial deal, you always want to get a bulk sales letter done. And if the property has 3 or more units, you will always want to get a bulk sales letter done. Everything else in the middle can be a gray area where basically I recommend you reach out to an attorney to discuss and see whether it's something that would be applicable, because it really then becomes a case-by-case basis. There's not as much of an absolute. You can always, just to cover yourself, complete and send in the form. There's no cost whatsoever to complete the document, attach the contract, and send it to the state. Provide your buyer guaranteed protection. The other backup option is to contact your title company and say, hey, is this something that we need bulk sales on? And they'll be able to give you an answer. But like I said, in 99% of deals, this does not apply. In your regular run-of-the-mill transaction where the buyer and a seller, where they're selling a house that they've lived in, it's not applicable. So it's not necessarily something to get crazy concerned about. But at the same time, if you have a deal that's a little bit different than a regular standard run-of-the-mill deal, you might want to just ask the question just to make sure that you're covered. All right. Paragraph 22 just is a notice regarding insurance. Obviously, your buyer should get homeowners insurance. There's really no question about that. Mortgage, no mortgage, doesn't make a difference. Get homeowners insurance. Pretty straightforward, pretty standard. All right. Maintenance and condition of the property. So paragraph 23 is a blanket provision in the contract that requires that the seller deliver a property to the buyer, essentially with functioning condition as it relates to electrical, plumbing, heating, and air conditioning systems.
Sure.
Right. Further, the property has to be in broom clean condition. So, number one, buyer's expectations need to be kind of managed to say you're not going to get a home that's been professionally cleaned. Every once in a while, sellers do it, but it's not the common thing. The idea is the house should be empty, and it really just shouldn't be a disaster. If it's fairly clean, almost all buyers that I've represented, the first thing they want to do to get into a house is to clean it themselves. That's going to still be the case. Now, if there are things that are left behind, that's a different conversation. There are plenty of times, it seems like especially lately this year, that sellers are just kind of taking the position, well, I didn't get everything out, so I'm leaving it. Well, that's not an acceptable thing. So if you have a buyer that you're doing your walkthrough and you find that there are items left behind, that's something that needs to be addressed. A lot of times these 1-800 junk companies can be called. You can bring them in and essentially agree to a concession or some sort of holdback to make sure that that gets done. If you have sellers, just tell your clients, get everything out. I mean, a lot of times people want to try to be nice and leave behind old flooring or paint and things like that. I can't tell you how many times that, paint gets left behind. 99 times out of 100, the buyers don't want your paint. They're going to repaint the house probably to their colors. Your old paint just becomes something that they have to get rid of. So my advice to sellers is generally just get everything out of the house. Now, this paragraph, though, is something that when I represent a seller, I will always make a change to. And that's because your buyer will have done a home inspection. And if there is anything that comes up in the home inspection that addresses the condition of the electrical, plumbing, heating, or air conditioning, that's the time for this to be negotiated. So if an inspector points out some outlets that are not grounded or GFIs or some other issue, the buyers don't request it. I like to eliminate the ability for them to make that request on the walkthrough, because the whole purpose of doing the inspection is to identify what's wrong with the house, negotiate it, and then at that point, subject to any agreements, the buyer should take the house in that condition. It should not be an intent that they come back and renegotiate things, an hour before settlement, that were identified by their home inspector. So if you have a buyer, make sure that if you're going to address things that fall into these categories, address them during the inspection phase. It's not really an idea to come back and have a double, second bite at the apple for negotiation purposes. So this kind of dovetails into the walkthroughs. When you're doing your walkthroughs, you should be looking to make sure that the house is in the same condition as you saw it when you did the home inspection. If something has changed, that's the reason we have a walkthrough, is to make sure that nothing new is either damaged, broken, or not operating properly. I know in PA, I'm sure there's walkthroughs as well where you kind of go through the same process. The walkthrough is the same time when you're going to go through and make sure the seller is fully moved out and the house is in acceptable condition. The big thing that I can kind of stress here is if there's an issue on the walkthrough and you don't address it before finalizing closing, it's not an issue anymore, because once you've signed the documents and completed closing, you're not able to go back. Things that you should have identified on the walkthrough, that's your chance. If you miss it and it goes through and they find it a day later, unless it's something that was concealed by the seller, frankly, your buyer's kind of out of luck. So make sure when you do the walkthroughs, turn on the faucet, flush the toilets, check everything, turn on all the light switches, test the garage doors, make sure they open and close, turn on the heater or the air conditioner, depending on the season, test everything out, because that's really your chance to go through and find those things. All right. Risk of loss. This paragraph is here to essentially cover in the event that there's a substantial damage to the property during the pendency of the sale. If tornado comes through, and I actually had this happen earlier this year. It actually came through in an area in, I think it was Monmouth County, and tore the siding off of a house. That's something where we have to go out, evaluate it, advise the buyers that, hey, we had a big issue here. This is what we're working on. If it's a substantial issue that can't be repaired before closing, it does not constitute a breach of contract on the sellers. Things happen. There are major events that they can't protect against, but it also does give the ability that if a resolution can't be worked out, the buyers can cancel, get their deposit back, but the sellers are also protected too. So this is really only in the event of those catastrophic issues. It does accept ordinary wear and tear. So, the house is being lived in. It's expected that you get a tiny stain somewhere, or, there's a tiny chip in the paint. Those types of things are, not really a big deal. It's kind of for major issues. Adjustments at closing. This is basically your standard split of costs. When you go to closing, taxes are prorated based on the date of closing. Water and sewer bills are prorated based on the day of closing, things that are all standard. The biggest kind of thing to keep an eye out for here is, depending on where you're closing or where the property is located in the state of New Jersey, is the 1/2 of the charge by the title company. So the contract provides that the seller and buyer are going to split 1/2 of the title company charges. That's the settlement fee. It's usually around $225, $250. The standard is for this to be split. It happens in essentially all the South Jersey counties. So Burlington, Camden, Gloucester, Cumberland, Cape May, Atlantic, and Salem. I think those are the ones that would happen. In Central and North Jersey, it's custom for the buyer to pay those fees. So you'll get, if you have a buyer that's buying a property in Middlesex County, you should expect the seller's attorney to send a letter removing this provision. That is completely normal and expected in the Central and North Jersey counties. But in South Jersey, our custom is for that to be split. So that's just kind of a heads up. The other big heads up that's in this section is what we call the mansion tax. And that's this paragraph here. In the event you have a buyer that is purchasing a property that exceeds $1 million, so $1 million and a penny and up, they're going to get charged 1% of the purchase price, basically as a tax to the state of New Jersey. So if you have a buyer that's putting an offer in a really nice house that's going to be in that 7-figure range, try to get creative and keep that number under $1 million. Otherwise, they're getting hit with a tax of at least $10,000. So what I have a lot of times is, if there's offers that are in the $1 million, $1.25 million range, I'll have my buyers propose to cover the commissions out of their pocket and lower the purchase price to below $1 million. So instead of paying $1.25 million, you can pay 6% is $60,000. Maybe you pay $30,000 in commissions and offer $995. That saves your client basically 10, 11 grand, and it's completely worthwhile. You have to be careful how far you manipulate it. Obviously, taking a house that's worth $1.5 million down to below $1 million is pretty difficult to do. The state's going to catch on to that. But anything within a reasonable number of that $1 million, get creative, get that number down, because otherwise your clients really, if you have buyers, are just basically lighting money on fire that they could otherwise save through creative negotiation. So big important thing with that is make sure your clients know that if you're selling, you're involved in a buyer sale for a property over $1 million, make sure they know that this tax is involved. Because if you get there on the date of closing and there's a $10,000 line item, I guarantee you they're not going to be happy and they're going to have some questions. So, if you're fortunate enough in the ability to be, having a buyer that's buying one of these and getting that good commission, make sure you're aware of it and make sure they're aware of it. Okay. All right. Paragraph 27, issues with closings. Basically, what the state of New Jersey says is if a party defaults on their contract, the other party can sue them. What they can sue them for, their actual damages, or in theory, specific performance. Specific performance means the actual forcing of the party to either buy the property, if it's the buyer that's breaching, or sell the property if it's the seller that's breaching. The history in the state of New Jersey is that a judge in almost any circumstance will not force a buyer to actually buy the property if they default. Instead, what will happen is the buyer will be responsible for financial damages. On the flip side, there are some occasions where a buyer can force a seller to sell a property, not just get monetary damages. In either of these events, this is something that obviously a buyer or seller would need to hire counsel, and they're going to want to look for somebody that's a litigation counsel specialist. Like, for example, I do not handle litigation. My role is representation in transactions. There's a lot of things that are involved in litigation and a lot of different things. You want to make sure that if they're going down that route, they hire somebody that does that every day. Because you get the wrong attorney who's going to tell you, sure, you can recover this and recover that and recover the other. It's really limited to what their actual out-of-pocket damages would be. Sadness, emotional distress, all of those things are not compensable. So, the question I get a lot of times is with a seller who's under contract, they've got a $5,000 deposit, and the buyer decides, I don't like the house anymore. I know you've agreed to fix everything in the inspection request that we submitted, but I don't want to move forward. And the sellers will always ask me, well, we just want to keep their $5,000 deposit. Well, it might not be that easy. You can always offer that and say, look, we'll let you out of the contract in exchange for you releasing that deposit. But the buyers could simply say, no, you can come after me. And at that point, what happens is your seller has to relist the property, get a new buyer, go through, complete the sale, and then actually calculate what the difference is in the purchase price, what their carrying costs were, whether they had any mover fees, any additional repair fees. And that's what would constitute their actual damages that they can keep. If that's not over $5,000, they go to court, they're not going to win that entire deposit. So that's when it becomes, important to maybe negotiate that. In most instances, if there's a breach of contract, the parties usually will try to work out some split or release of the deposit, because unless you're talking about major damages, the only people that win in these litigations are the attorneys that charge probably more than your client's going to recover for damages. So in most instances, it's not worth going the litigation route. Taking the deposit, negotiating it, and moving on to another buyer if you have a seller is usually the way to go. Now, the last line is important here, because what it states is that in the event there is a breach of contract, the breaching party is actually required to pay both sides commissions. So it's not very common that this actually comes forward, and in any deal where there's attorneys involved, that sentence gets deleted. But the Board of Realtors has inserted this protection for you all that says you worked hard, you got the property under contract, it's ready to go, and then one of the parties has defaulted. You have the right to go after that defaulting party for the commission. It's not all that common that it happens, but sometimes when things get ugly, and if there's going to be a lawsuit filed and it's enough money, those commissions are sought, and it's usually not against your own clients, usually against the other side of the deal. But that's just something for you to keep in mind, that is a potential avenue for recovery to get reimbursed for the work that you did put in. All right, next couple of paragraphs just deal with the relationship that you as brokers and agents have with the parties. Here obviously is the area you'd be filling in your information, the other agent's information, and commissions. I don't like the reference to listing agreement that's contained in here. My recommendation is always that when you're representing a party, make sure that your actual commission percentage, or if it's a flat fee, is included. You don't want to have to dig out an agreement and somebody challenges whether the agreement was signed and agreed to. Put the commission in the contract. That way it's very easy. The title company can pull your 3%, 2.5%, plus minus whatever it may be, easily out of there, and there's no dispute. It's very easy. In furtherance of the commissions, paragraph 31 actually places a lien on the property for your commissions. It's not a lien that gets recorded anywhere, but it's what's called an equitable lien, which means that in the event the property gets sold and you don't get paid, you have the right to go back after the seller for your commission, because this contract essentially guarantees that it has to be paid from the proceeds so long as there's a sale that occurs. Next couple paragraphs just deal with the fact that paragraph 32 is selected in the event the buyer or the seller is a broker, agent, someone involved in real estate world. It has to be disclosed. Next paragraph provides that you as agents are entitled to the closing documents. I believe Keller, at least in the South Jersey, Keller Williams require that documents be turned over following settlements. You need to get a copy of the CD Alta, things like that. This gives you the right to get those. Paragraph 34 is your protection that when you send out referrals, you're not making guarantees. So if you refer a home inspector, title company, contractor, an attorney, you're not saying that this professional is going to be the best you've ever seen. We're just saying this is somebody that you can call. It's up to you if you want to, and if you retain them, that's up to you to retain. It's on you as a buyer or seller to do so. Paragraph 35 is the attorney review provision. So this is something that New Jersey has that provides the ability for realtors to draft contracts and get them out and get them signed quickly. Frankly, attorneys don't turn around contracts as quickly as you all do, because when we do contracts, we have to get all the information, we're typing them together, or our staff, or however it's getting done. There's usually a little bit of back and forth to make sure we have all the details right, and then the contract gets turned out. My experience is typically when agents put them together, they get them out same day, they're out, they're signed, they come back, it's much quicker. Now, one thing I will highlight and to always pay attention to is when an attorney does prepare a contract, we do not have to insert an attorney review provision in our contracts. So I draft a contract, there's no attorney review. Once the parties have signed it, it's fully binding immediately upon the second signature and delivery. There are pluses and minuses to that. The plus is, and I've used this a lot in this market, if I have buyers that keep losing out on houses because they sign a realtor contract and then the seller finds another buyer during the 3-day attorney review, we can avoid that because we send out a contract, it's signed, the seller signs it, there's no more shopping those offers. It's a done deal. The downside, of course, is that it's not a standard contract. The other side may want to get an attorney involved to review it, make sure that there are no outlandish provisions or anything that's unfair. But if both sides are going to have an attorney, I find that using a pre-prepared contract a lot of times isn't such a bad thing. It gets things sped up and gets it done. So it is an option that you have, but the thing that you need to make sure is if you're having your client sign a contract and it is not clearly this standard contract, do not let them sign it without having a lawyer review it first, because there are contracts that do float around from some rehabilitation entities. I haven't seen it now in about 2 years, but it was a pretty common thing 3 or 4 years ago, where they inserted really onerous provisions that related to the mortgage commitment and basically said, if you don't get a commitment in 7 days, you're waiving your rights to cancel the contract for not getting a commitment. Contract looked identical almost otherwise, but it did not have attorney review and it had that provision in there. And they were basically trying to sell a mortgage from their company at high rates. It was a pretty bad scam that was going on. And so some people were getting taken advantage of. So you always want to make sure before you let your client ever sign a contract without review, that this paragraph 35 regarding attorney review is in there. If it is, and your clients sign it, your clients then have 3 business days following the signing of the contract. That means if it's signed on a Friday, Saturday, or Sunday, attorney review would not begin until the following Monday, unless that Monday is a holiday, Memorial Day, Labor Day. In that case, it begins on Tuesday. So anytime that there's basically a male holiday is the way that I'll classify it. That day does not count in your 3 business days. Otherwise, Monday through Friday, those 3 days count. And the time that matters is not end of business. There's no definition of end of business in the contract. It's 11:59 p.m. Okay. All that has to happen to disapprove of a contract is an attorney sends an email saying, I disapprove of this contract. That's it. The whole standard, it used to require certified mail. Supreme Court in Jersey said that's no longer required. I can send an email to the agent on the other side canceling the contract. I can also send an email on the other side saying, we disapprove, but here are some requested changes. That's typically what happens. You'll get a list of changes to the contract, some of which are probably standard, some of which may not be. My recommendation is always, if you receive an attorney review letter, have your clients hire an attorney to review that and respond. You don't want to get in the business of playing lawyer and trying to interpret these provisions, because you can get yourself in trouble, because your client will always come back and say, well, you told me that this is what it says, and now it's not. Now I've got a problem. And instead, you should have told me to get a lawyer. So, a lot of attorneys will charge different rates for attorney review as opposed to the entire representation of the transaction. I know I do. My fee is about a third for the attorney review as it would be for the full transaction. Some people just want me to make sure the contract is good, review the other side's addendum, and then they're good from there. And that's perfectly fine. But just for your own protection, I never recommend you making comments on an attorney review addendum because really you're playing lawyer at that point, and that can get you in trouble. All right. Notices in the contract will always be sent to the agents that are involved and the attorneys. Email and facsimile are always acceptable. Things don't have to be by mail anymore, obviously. Importantly, and this is something that is often overlooked, this contract is not assignable. So there are buyers that will go out there and go under contract and then seek to resell the property. Unless they have changed the contract to add a provision that the contract is assignable, your seller never has to agree to an assignment, and that buyer is on the hook to buy the property. Same thing if you have a buyer and they plan on shopping it, they're a wholesaler, make sure the contract is altered to allow assignment of the contract. A lot of times, assignments that I'll see is a buyer goes under contract and they ultimately intend to purchase it in the name of an LLC. That's pretty simple. You just insert a provision that the contract is assignable to any buyer-owned entity. Usually you won't run into any trouble there. The bigger pushback is if it's somebody that's a wholesaler trying to shop the contract. All right. Corporate resolutions just deals in the event that there is an entity that's involved. In order for an entity to either buy or sell a contract, they need a corporate resolution. It's a simple one-page document that basically has the members or authorized members of the entity sign off saying that so-and-so is the certified signer, that they can go to closing and sign documents to bind the entity. So a company will require this. Attorneys prepare these all the time. It's a very nominal charge, really simple document. Many LLCs can also find it, Google it, create their own and sign and have it notarized. Just something to be aware if you have an entity involved in the transaction. Paragraph 40 just indicates that you're not making representations, that the contract is the contract. So anything that's not written in the four corners of this contract that you may have discussed during your offer, it's not a part of the contract. So if you have something that's important, make sure it gets added. We can't go back later and say, well, when we were talking about making the offer, you said you were going to include this piece of furniture. It's not in here. It's not an addendum of the contract. It's not something you go back to later and force to be in there. Everything is subject to the laws of the state of New Jersey. And then if you recall last time, we talked about a certain addendums that New Jersey has. This is kind of a list of those things. Some of these are applicable. A lot of times they're not all going to be applicable in any instance. But every once in a while, something may pop up, and this would give you the easy ability to attach. If there's a homeowners association, you're going to want to use that. If there's a property sale contingency, your buyers are buying, but they have to sell their house first. New construction, FHA, VA loans, your lender's going to require this. So that's something that you're going to need to have attached. And then finally is the additional contract provisions. This is the section of the contract where you can put in anything you want. I say that, but be careful. Anything that you put in here is a legal term that you're adding to the contract. So it's common, it happens all the time. Make sure whatever you insert here, you say what you mean what you say, and it's unambiguous and very clear. If you send in a paragraph that's ambiguous, that's where things can kind of devolve and cause problems. The biggest one that I usually see has to do with modifications of either appraisals, appraisal waivers, or coverage of a certain amount of an appraisal, or inspections, limitations, whether it be, my favorite phrase, the informational purposes that we discussed last time. If you're going to modify inspections, like I said, say what you mean. If the buyer is allowed to do an inspection but not make requests, don't say informational purposes. Say the buyers can do inspections, but they're not permitted to make requests. Reference paragraph 16 of the contract that talks about inspections. So if you're modifying something that's already in here, make sure you make a reference to whatever you're modifying. When in doubt, don't make the modification. Have your clients hire an attorney to make the modification, so that way you're covered and nobody can come back and point the finger at you for drafting something that doesn't either reflect what the agreement was or is ambiguous. So I know we kind of breezed through a lot. The second half of the contract is a little bit lighter in terms of things than the first half. So why don't I open it up for anybody that has any questions, basically about anything, either last session, this session, anything contract related, fire away.
So I have a question for you. So
Sure.
if an agent's representing either whatever, a buyer or a seller, and they're uncertain about certain things and they would prefer to hire an attorney, but the buyer or seller doesn't want to. Can they engage you?
So here's the way I always work it is agents can call me and ask me questions anytime. That's kind of the way that I work is my entire business is based on referral. So if you've got a question and need something, give me a call. We'll discuss it, see what's involved, and then I can make recommendations. A lot of times when it's something like that, Deidre, my recommendation is that you're going to tell your client, I'm not a lawyer. I can't give you advice to this. However, I spoke with an attorney and he or she is willing to help you out. I highly recommend it. But my role as your realtor, and if we go back to, there's like an introductory page in the contract, which I don't think I have attached here. Yes, this introductory page right here clearly says that you will not get any legal advice unless you have your own lawyer. This is what you as agents want to go back and point to. You're here to give them advice as it relates to buying a home, selling a home, the comps, some of the things in the closing process, but this is a 13-page legal document. You're always able to default back to this and say, I'd really recommend you contact a lawyer. I spoke to a lawyer. He understands or she understands what's going on and has some opinions that can help you out. But in terms of let's say you called and wanted me to retain you, my advice to you is going to be don't give legal advice. Have your clients hire a lawyer because you can't give that legal advice. So, but in any event, contact me with questions anytime, shoot me an email. I never have problems with that. I'll always answer whatever you have. That's kind of the way that I handle things.
Thank you very much.
Yeah, of course. Other questions? No? Okay. All right. Well, that kind of wraps up the contract. Like I said, I think we handled a lot of the heavy lifting last time that we all met. So I appreciate everybody's time. If you have any questions, feel free to give me, shoot me an email, give me a call. I'll be more than happy to help. And that's it. So everybody have a good rest of the day. Have a good holiday season coming up, and hopefully
Thank you.
Can I
so much.
have your contact information, please?
Yeah, sure. Let me put it in the chat right now. Give me 1 second here. I'll type it. Thanks, everybody.
Thank you so much.
Take care.
Bye.